perhaps repeatedly, cases involving patterns of obstruction compounded by subsequent cover-up perjury. The President's lawyers may very well try to weave a spell of complexity over the facts of this case. They may nitpick over the time of a call or parse a specific word or phrase of testimony, much as the President has done. We urge you, the distinguished jurors in this case, not to be fooled. Use
from Iowa.
Mr. Chief Justice, I object to the use and the continued use of the word jurors when referring to the Senate sitting as triers in a trial on the impeachment of the President of the United States. Mr. Chief Justice, I base my objection on the following. First, Article 1, Section 3 of the Constitution says the Senate shall have the sole power to try all impeachments. Not the courts, but the Senate. Article 3 of the Constitution says the trial of all crimes except in the cases of impeachment shall be by jury. A tremendous exculpatory clause when it comes to impeachments. Next, Mr. Chief Justice, I base my objection on the writings in the Federalist Papers, especially Federalist Paper number 65 by Alexander Hamilton, in which he is outlining the reasons why the framers of the Constitution gave to the Senate the sole power to try impeachments. I won't read it all, but I will read this pertinent sentence, where Mr. Hamilton says, and I quote, "There will be no jury to stand between the judges who are to pronounce the sentence of the law and the party who is to receive or to suffer it." Next, Mr. Chief Justice, I base my objection on the 26 rules of the Senate, adopted by the Senate, governing impeachments. Nowhere in any of those 26 rules is the word juror or jury ever used. Next, Mr. Chief Justice, I base my objection on the tremendous differences between regular jurors and senators sitting as triers of an impeachment. Regular jurors, of course, are chosen to the maximum extent possible with no knowledge of the case. Not so when we try impeachments. Regular jurors are not supposed to know each other. Not so here. Regular jurors cannot overrule the judge. Not so here. Regular jurors do not decide what evidence should be heard or the standards of evidence, nor do they decide on witnesses or what witnesses shall be called. Not so here. Regular jurors do not decide when a trial is to be ended. Not so here. Now, Mr. Chief Justice, it may seem a small point, but I think a very important point. I think the framers of the Constitution meant us, the Senate, to be something other than a jury and not jurors. What we do here today is not just to decide the fate of one man. Since the Senate sits on impeachment so rarely, and even more rarely on the impeachment of a President of the United States, what we do here sets precedents. Future generations will look back on this trial, not just to find out what happened, but to try to decide what principles governed our actions. To leave the impression for future generations that we somehow are jurors and acting as a jury.
Mr. Chief Justice, could I call for regular order at this point?
The chair recognizes the senator from New Hampshire.
I would ask, as a parliamentary point, whether it's appropriate to argue what I understand is a statement as to the proper reference relative to members of the Senate. This is not a motion, as I understand it. If it is a motion, it's not debatable, as I understand it.
Mr. Chief Justice.
I think you may state your objection, certainly, but not argue it. The chair views that you may state the objection and some reason for it, but not argue it ad infinitum.
Yes, I was just stating the reason for my objection because of the precedents that we set, and that I do not believe it would be a valid precedent to leave for future generations that we would be looked upon merely as jurors, but something other than being a juror, and that's why I raise that objection, Mr. Chief Justice.
The chair is of the view that the senator from Iowa's objection is well taken, that the Senate is not simply a jury, it is a court in this case, and therefore counsel should refrain from referring to senators as jurors.
I thank the court for its ruling. We urge you, the distinguished senators sitting as triers of fact and law in this case, not to be fooled.